Good morning, friends. My today's topic is on Article 254, Supply 2 of the Constitution of India 1949. We all know that this subclause 2 of Article 254 is read as where a law made by the legislature of a state with respect to one of the matters enumerated in the concurrent list contains any provision repugnant to the provisions of an earlier law made by Parliament or an existing law with respect to that matter, then the law so made by the legislature of such state shall, if it has been reserved for the consideration of the President and has received his assent, prevail in that state, provided that nothing in this clause shall prevent Parliament from enacting at any time any law with respect to the same matter, including a law adding to, amending, bearing, or repealing the law so made by the legislature of the state. To go more in detail about this provision, I am taking the help of one of the important latest judgment of the Supreme Court of India under its civil appellate jurisdiction, that is Civil Appeal number 5692 to 5695 of 2021. The facts are long ago the state of Tamil Nadu chose to exercise its right of eminent domain to acquire land for its Harijan welfare scheme and its industrial purposes and its highways by deviating from the law and procedure prescribed in the central legislation, namely the Land Acquisition Act of 1894 of the central legislature. In exercise of its concurrent power under entry 42 in the list third of the seventh schedule to the Constitution of India, it enacted the Tamil Nadu Acquisition of Land for Harijan Welfare Schemes Act 1978, the Tamil Nadu Acquisition of Land for Industrial Purposes Act 1997, and Tamil Nadu Highways Act 2001. These three state acts stood protected despite being repugnant to the Land Acquisition Act of 1894. You can say the old LP Act, owing to the presidential assent that they had received on 21st July 1978, 25th May 1999, and 16th September 2002, respectively, under Article 254, Subclause 2 of the Constitution. Where the problem arose, however, upon the Parliament promulgating the right to fair compensation and transparency in land acquisition, rehabilitation and resettlement act 2013, you can say the new LA act replacing the old LA act. These state acts were rendered void, being repugnant thereto. Pertinently, section 105 of the new LA Act provided that the said legislation would not apply or would apply with modifications to the central government enactment relating to land acquisition specified in the fourth schedule there. In an attempt to save the three state acts by taking a cue from the section 105 of the new LA Act, The Tamil Nadu Legislative Assembly passed Bill number 5 of 2014 on 22nd February 2014, amending the new LA Act. Thereby, Section 105A was inserted in the new LA Act, making the provision thereof inapplicable or applicable with modifications to the Act relating to land acquisition in the state of Tamil Nadu, which were specified in the newly added fifth schedule. The three state acts were shown in this schedule. However, Bill number 5 of 2014 was returned by the President of India, pointing out some defects, and after curing of the same, it was reintroduced as Bill number 30 of 2014. It was then sent to the President of India for his assent and received the same on 1st January 2015. In consequence, the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement, Tamil Nadu Amendment Act 2014 came into force with retrospective effect from 1st January 2014. Now, the Act number 1 of 2015 was subjected to challenge before the Madras High Court in a batch of writ petitions. Writ petition number 21323 of 2015 was also filed, raising a challenge to the Tamil Nadu Highway Act 2001, for brevity the Highway Act. On the same line, writ petition number 26028 and 26234 of 2013 were filed, assailing the validity of Tamil Nadu Acquisition of Land for Industrial Purposes Act 1997, for brevity Industrial Purposes Act, on the ground that it was ultra vires the Constitution of India, and seeking a consequential direction to the authorities to drop the acquisition of the petitioner's land thereunder. In writ petition number 2026 of 2013, the consequential prayer of the two petitioners, that is, namely P.K. Muralidharan and V. Thirunarayanan, why to direct the authorities not to acquire their land in old survey number 93, subclass 4B, presently survey number 93 oblique 58 and 93 oblique 59. The prayer of C.S. Gopalakrishnan, the petitioner therein, why to direct the authority to return his land in survey number 92 oblique 60. The second petitioner, in writ petition number 26028 of 2013, also filed writ petition number 10282 of 2015, seeking a declaration that the Act number 1 of 2015 was ultra vires the Constitution and consequential direction to the authorities not to acquire his land in Kanchipuram district. Similarly, C.S. Gopalakrishnan, the sole petitioner in writ petition number 26234 of 2013, filed writ petition number 10283 of 2015, seeking identical urges. So these four writ petitions, along with several others, were partly allowed by the divisional bench of the Madras High Court by common order dated 3rd July 2019. What was the common order? The common order dated 3rd July 2019 reflects that the High Court framed the following issues for consideration. First one was, are the state enactments void because of inherent arbitrariness? Second issue framed was, did the President of India fail to apply his mind while granting assent to Section 105A? Third issue was, did the impugned state enactments became repugnant once the Parliament made the new Land Acquisition Act? If so, did the presidential assent to Section 105A inserted by Tamil Nadu Act 1 of 2015 revive the three acts? Fourth issue was framed, are the provisions of Section 105A subclause 2 and 3 are mandatory, and if so, whether non-compliance with these provisions fatal to the validity of these enactments. So, as regards the first issue, that is, are the state enactments void because of inherent arbitrariness? The High Court noted that the validity of the Tamil Nadu Acquisition of Land for Harijan Welfare Scheme Act 1978 was upheld by the Supreme Court in state of Tamil Nadu and other versus Nanthi Ammal and others 1995 Volume 1 SEC 519, and that the Industrial Purposes Act was upheld by Division Bench of the Madras High Court in K. Ramakrishnan versus State of Tamil Nadu 2007 WLR 372, wherein it was specifically held that the said enactment did not suffer from any illegality, irrationality, or procedural impropriety. Similarly, the Tamil Nadu Highways Act 2001, for brevity, the Highway Act was upheld by the Madras High Court in S.N. Samathi versus State of Tamil Nadu and others 2015 SCC Online Madras 14055. The High Court therefore opined that the three state acts could not be said to be irrational, capricious, or without adequate determining principle, and rejected the contention that they were liable to be invalidated on the ground of inherent arbitrariness. And on the second issue, the High Court held that all the three material, all all the material was placed before the President of India. Therefore, it could not be said that there was any non-application of mind by the President of India while granting assent. The High Court also noted that the first bill was returned by the President, pointing out some facts, and it was only after the same were cured that the presidential assent was given. The second issue was decided accordingly. The third issue, High Court accepted the contention of the writ petitioner that the new LA Act received presidential assent on 27th September 2013. All the three state acts become void on that day itself, and Act number 1 of 2015 did not have the effect of reviving these void state acts. It was noted that Article 254 subclause 2 of the Constitution would not apply to law already made by the state which become repugnant as a result of new enactment made by the Parliament, and it would not offer protection to laws made by the state before the central legislation. The High Court appoints that Article 254 subclause 2 of the Constitution required the repugnant law to be reserved for consideration afresh by the President for giving assent thereto, and therefore these state acts had to receive presidential assent in the present sense. The High Court concluded that in order to bring an act within the purview of Article 254, subclause 2 of the Constitution, it must be reenacted by the state and reconsidered by the President, and mere insertion of Section 105A in the new LA Act was inadequate. The High Court accordingly declared the three state acts void and held that Section 105A did not restrict them and was mere a dead letter. On the last issue, the High Court held Section 105A, subclause 2 and 3 to be mandatory. Holding so, the Madras High Court allowed the writ petitions to the extent indicated. However, the High Court deemed it appropriate not to reopen the acquisitions made under the State Acts on or after 27th September 2013, where the acquired land had already been put to use and purpose for which the lands were acquired had been accomplished. The High Court held that as Section 105A inserted in the new LA Act by Act of 1 of 2015 was rendered virtually auto as Act number 1 of 2015 did not meet the requirement of Article 254 subclause 2 of the Constitution and did not have the effect of reviving the state acts. The validity of Section 105A need not be independently examined. So, SLP C number 2063 to 2066 of 2020, which were thereafter numbered as Civil Appeal number 5692 to 5695 of 2021, arose out of the Common Order dated 3rd July 2019 insofar as it pertained to writ petition number 26234 and 26028 of 2030 and writ petition number 10282 283 of 2015 respectively. The second petitioner in writ petition number 26028 of 2013 and Shri C.H. Gopala Krishnan, the sole petitioner in writ petition number 26234 of 2013, filed the first two SLPs aggrieved by the Common Order to the extent that it did not hold the Industrial Purpose Act to be void on the ground of arbitration, arbitrariness and violation of Article 14 of the Constitution. The other two SLPs filed by them pertain to writ petition number 10282 and 283 of 2015 respectively, relating to the validity of Act 1 of 2015 and Section 105B. During the pendency of the SLP before the Honorable Supreme Court, the state of Tamil Nadu again attempted to revive the three state acts by enacting the Tamil Nadu Land Acquisition Law Revival of Operation Amendment and Validation Act 2019. For brevity, the Validation Act of 2019. This act received the assent of the President under Article 254, Subclause 2 of the Constitution on 2nd December 2019. It came into effect retrospectively from 26th September 2030. The Validation Act of 2019 was challenged before this Honorable Court in a batch of writ petitions. By judgment dated 29th June 2021, reported in G. Mohan Rao and others versus State of Tamil Nadu and others, AIR 2021 SC 3126. Honorable Court held that the said enactment was a legitimate legislative exercise which was consistent with and fell within the four corners of Article 254 of the Constitution. The writ petitions were accordingly dismissed. It may be noted that one Mr. K. M. Vittal Babu and one T. Chinnappan had filed writ petition number 5893 of 2018 before the Madras High Court, wherein they had sought a declaration that Section 105A inserted in the new LA Act by Act of number 1 of 2015 was unconstitutional. This writ petition was also clubbed with the batch of writ petition which came to be disposed of by a common order dated 3rd July 2019. While so, on 7th July 2021, K. M. Vittal Babu and T. Chinnappan filed interim application number 77573 of 2021 in SLP number 2063 to 2066 of 2020, which were numbered as Civil Appeal number 5629 to 5695 of 2021, seeking to be implemented therein. They stated that the provisions of the Industrial Purpose Act are in pari materia with the provisions of the Highway Act, whereunder their lands were acquired, and so there was no separate petition dealing with the validity thereof. It was just a necessity that they get implemented in SPL number 2063 to 2066 of 2020 so as to question the paramateria provisions of the Highway Act. Their implement application was allowed on 9th September 2021. Surprisingly, 2 days later, on 11th July 2021, K. M. Vittal Babu chose to file SLP Civil Diary number 15466 of 2021 in the context of writ petition number 21323 of 2015, referred to herein before, wherein he was not a party. In his application for permission to file the SLP, he stated that writ petition number 21323 of 2015 raised a challenge to the Highway Act, which was missing in his own writ petition, and he therefore wanted to raise that issue before this court. He was granted leave to do so on 9th September 2021, and his SLP was numbered as Civil Appeal number 5697 of 2021. His prayer therein is to declare the Highway Act unconstitutional and void. Thus, K. M. Vittal Babu figures as the appellant in Civil Appeal number 5697 of 2021, and is also implemented as a respondent in other appeals along with T. Chinappa. In the light of G. Mohan Rao Supra, the challenge before this court to Act Number 1 of 2015 and Section 105A are rendered redundant. SP, SLP number 4106 of 2020 involving such a challenge was disposed of on 9 September 2021. Therefore, issue number 2, 3 and 4 dealt with by the High Court in the common order dated 3rd July 2019 no longer required consideration on merit. In consequence, though numbered thereafter, Civil Appeal number 5694 and 5695 of 2021 are infructuous and need no adjudication. The only issue left for consideration is whether the Industrial Purposes Act and Highway Act are void owing to inherent arbitrariness and infringement of Article 14 of the Constitution. In this context, it may be noted that in paragraph 74 in G. Mohan Rao, this court observed that the contention based on comparative analysis of state acts and new LP Act to establish violation of equity clause under Article 14 of the Constitution is left open. Parties were given liberty to raise all other issues not dealt with in that judgment in relation to validity of state laws in the pending cases arising from the order dated 3rd July 2019, including the getting themselves implemented. So, the Honorable Supreme Court heard Mr. Soharit, Land Counsel for the appellants in Civil Appeal number 5692 and 93 of 2021, Mr. N. Subramaniam, Land Counsel appearing for K.M. Vittal Babu and T. Chinappa, and Mr. K.K. Venugopal, Land Senior Counsel appearing for the state of Tamil Nadu and its authorities. Civil Appeal number 5692 5693 of 2021. The Industrial Purposes Act is founded on the premise that the state of Tamil Nadu found it expedient to make special provision for speedy acquisition of land for industrial purposes in the state of Tamil Nadu and for matters connected therewith. The scheme therein envisages that government would cause a public notice to be given under section 3 subclause 2 of the Industrial Purpose Act in such a manner as may be prescribed, calling upon the owner of the land and any other person who in the opinion of the government may be interested in such land to so cause within such time as may be specified in the public notice why the land should not be acquired. Section 3, subclause 3 provides that after hearing and considering the cause, if any, shown by the owner or person interested, the government may pass an order under section 3 subclause 1. In turn, section 3 subclause 1 states that government may acquire any land required for any industrial purpose or for any other purposes in furtherance of the objects of the Act by publishing a notice in the Tamil Nadu Government Gazette specifying the particular purpose for which the land is required. Once the notice under section 3 subclause 1 is published in Gazette, section 4 states that the land would vest absolutely in the government free from all encumbrances on and from the date of such publication. The gravamen of attack in the present appeal is that the Madras High Court erred in holding that the Industrial Purpose Act was not liable to be invalidated on the ground of arbitrariness and violation of Article 14 of the Constitution. Various issues were raised in the course of argument in this regard, citing an abundance of case law. However, it is an admitted fact that C.S. Gopalakrishnan purchased the land in survey number 92/60, pata number 1317, plot number 236, Pille Pakhan village, Kanchipuram district, under registered sale deed dated 14 December 2012, long after initiation of the acquisition proceeding by issuation of public notice on 23rd October 2007 for setting up Sipcot Industrial Park. Similarly, B. Thirunarayanan, the other appellant, also purchased the land in old survey number 93/4B, presently survey number 93/58 and 93/59, Pille Pakhan village, Kanchipuram district, under registered sale deed number 21st February 2013, well after the initiation of the aforesaid stated acquisition proceeding. However, the notice under section 3(1) of the Industrial Purpose Act was published in the Gazette only in March 2013 after their purchase of land in question. In the above milieu, the question that would arise is as to the locus standi of the appellants who admittedly purchased their land after the initiation of land acquisition proceeding to maintain a challenge to the provision of the Industrial Purpose Act and proceeding initiated thereunder. It is the argument of the state that such subsequent purchaser would have no right to challenge the acquisition proceeding and in that context maintain an attack against the legislation under which such acquisition is made. It is further contended that as per section 3 subclause 1, notice were published in the year 2013 before the coming into force of the new LA Act. Determination of the compensation in relation thereto would be only on the basis of old LA Act and not under the new LA Act. Per contra, the appellants assert that they would have locus to challenge the validity of the Industrial Purposes Act as their sale transactions were nearly 6 years after the issuance of public notice under section 3 subclause 2 of the Industrial Purpose Act, and any reasonable person would have a bona fide belief that such proceedings would have lapsed owing to passage of time. They also contend that as per section 4 of the Industrial Purpose Act, the acquired land would vest in the government only on publication of notice under section 3 subclause 1, and therefore a sale transaction prior thereto would not be rendered void. They would argue that the state cannot freeze property rights for a period of 6 years by issuing a public notice under section 3 subclause 2 of the Industrial Purpose Act and forgetting about it thereafter for years together. Reference is made to the judgment of the Madras High Court in Shri Venkateshwara Educational and Charitable Trust versus Secretary to Government of Tamil Nadu and other writ appeal number 1063 of 2012, decided on 7 October 2022, which held that in cases where compensation still needed to be determined for acquisitions made under the Industrial Purpose Act, the new LA Act would apply perforce, and the base data for determining compensation would not be the date on which Section 32 notice was issued, but 112014, the date on which new LA Act came into force. It may be noted that after publication of the notice under Section 3 Subclause 1, the appellants are stated to have filed writ petitions before the Madras High Court in which orders of status quo were passed. Those cases are stated to be pending as on date. We are not concerned at this stage with the validity of individual acquisition proceeding initiated under the Industrial Purposes Act. If the validity of such acquisition proceeding is under challenge before the High Court, it is for the party to pursue the same and invite an adjudication on merit. Issues pertaining to such individual acquisition proceeding, including quantification of compensation and other aspects based on facts, can be decided on in those repetitions and need not concern us at this stage. Presently, we are only dealing with the challenge to the validity of the Industrial Purposes Act and Highways Act on the grounds of arbitrariness and breach of Article 14 of the Constitution and no more. As regards the issue of appellant's local standing, that very aspect was considered by a three-judge bench of this court in Shiv Kumar and another versus Union of India and others 2019, Volume 10, SCC 229. The question therein was whether subsequent purchasers of acquired land would be entitled to seek invalidation of the acquisition on the ground of delay under Section 24 Subclause 2 of the new LA Act. The bench held that a sale transaction effected after the notification under Section 4 of the old LA Act is void and would be ineffective to transfer the land, and such a sale would not close the subsequent purchaser with title whereby they could claim to be in possession. It was observed that it would be profoundly unfair and unjust and against the policy of law to permit such a purchaser to claim resettlement or claim the land back, as envisaged under the new LA Act. Support in this regard was drawn from the earlier judgments in UP Jal Nigam, Lucknow, and another versus Kalra Property Private Limited, 1996, Volume 3, HCC 124, Sneh Prabha and others versus State of UP, and another 1996, Volume 7, SCC 426, Union of India versus Shiv Kumar Bhargava and others 1995, Volume 2, SCC 427, Meera Sani versus State of NCT of Delhi and others 2008, Volume 9, SCC 177, V. Chandrasekhar and another versus Administrative Officer and others 2012, Volume 12, SCC 133, Rajasthan State Industrial Development and Investment Corporation versus Swas Sindhi Cooperative Housing Society, Jaipur, 2013, Volume 5, SCC 427, and Mr. Venkatvesh Venkatesh and others versus Commissioner of Bangalore Development Authority 2015, Value 7, SCC 1. Be it noted that in UP Jal Nigam Lucknow Supra, Meera Sani Supra, and B. Chandrasekhar Supra, this court held that such a purchaser could not challenge the acquisition and would at best be entitled to receive compensation. As both C.S. Gopal Krishnan and B. Thirunarayanan seek to sell the validity of the Industrial Purpose Act only in the context of the acquisition proceeding initiated therein in relation to land purchased by them after issuance of public notice under Section 3 subclause 2 thereof, namely the equivalence of notification under Section 4 of the old AL Act, their challenge is tainted and unacceptable in its very inception. They were both subsequent purchasers and are deemed to be aware of the acquisition proceeding. In that regard, we may note that the original owners of the subject land raised their objection in response to the public notice issued under Section 3, Subclause 2 in the year 2007, but chose to sell their land in 2012 and 2013. In any event, neither of these subsequent purchasers can be permitted to claim ignorance of the acquisition proceeding. In effect, the very sale transaction under which they claim title and interest in the subject lands are rendered void in the eye of law. Mere passage of time and publication of Section 3 subclause 1 notice after their purchase of the land would not save their sale transaction or vest them with the right to attack the acquisition. In consequence, we find no reason to entertain their challenge to the Industrial Purposes Act on the ground of arbitrariness and violation of Article 14 of the Constitution or their consequential challenge to the acquisition proceeding. Civil Appeal number 5692 5693 of 2021 are therefore liable to be dismissed on this short ground. Now coming to Civil Appeal number 5697 of 2021. K.M. Betel Babu and T. Chinappan assailed the common order dated 3rd July 2019, passed by the Madras High Court, whereby challenge to the validity of the Highway Act on the grounds of arbitrariness and violation of Article 14 of the Constitution were rejected. The grievance of two persons is with regard to acquisition of the land by the state of Tamil Nadu under the Highway Act. The government of Tamil Nadu had issued GO number 2200 Highways and Minor Ports Department dated 7th December 2011, proposing to acquire land for construction of flyover road overbridge to replace railway level crossing number 184 in Slave. Thereafter, public notice dated 2nd July 2016 under Section 15 subclause 2 of the Highway Act, which is the equivalent of Section 3 subclause 2 of the Industrial Purpose Act, was issued calling for objection so as to why their land should not be acquired for the said purpose. After consideration of the objection received, notice dated 1st February 2017 was published in the Tamil Nadu Government Gazette under Section 15 subclause 1 of the Highway Act, which is the same as Section 3(1) of the Industrial Purpose Act. Therefore, the two persons filed writ petition number 3276 of 2017 before the Madras High Court challenging the acquisition proceeding and the status quo was ordered therein. Their case is pending as on date. The Validation Act of 2019 states that the provision in the first schedule, second schedule, third schedule to the new LA Act shall apply to land acquisition proceeding under the Highway Act. Part 3 of the Validation Act of 1920, 2019 pertains to Highway Act. Section 10 subclause 1 therein states that all the provisions of the Highway Act except the provision relating to determination of compensation shall stand revived with effect on or from 26th September 2030. Section 10 subclause 2 states that all rules, notifications, notices, orders, directions issued or any other proceeding initiated under the Highway Act except those relating to determination of compensation which were in force immediately before 26th September 2013 shall all purpose be deemed to have been revived on and from 26th September 2030. Section 10 subclause 3 states that provision relating to determination of compensation as specified in first schedule, rehabilitation and resettlement as specified in second schedule, and infrastructure amenities as specified in third schedule to new LA Act shall apply to the acquisition proceedings under Highway Act. Section 11 states that except as provided in the Validation Act of 2019, the provisions of new LA Act shall cease to apply to any land which is required for the purposes specified in Section 15 subclause 1 of the Highway Act, and any such land shall be acquired by the government only in accordance with the provisions of the Highway Act. Though Civil Appeal number 569293 of 2021 are liable to be dismissed on the ground of maintainability, the arguments of Mr. Sohrit Parthasarthi, Land Council appearing then were adopted in toto by Mr. N. Subramaniam, Land Council for K.M. Vittal Babu and T. Chinnappan. This adoption of arguments is based on the premise that provisions of the Industrial Purpose Act are in paramaterial with the provisions of the Highway Act with which they are concerned. In that view of the matter, we shall advert to the arguments advanced by both the Land Council in the context of Highway Act alone. The Highway Act is stated to be discriminatory both with regard to determination of compensation as well as acquisition procedure when compared to new LA Act. Reference is made to the provision of new LA Act which require appropriate government to consult local authorities in the affected area and to carry out a social impact assessment study in consultation with them. It is pointed out that a social impact assessment study report would lapse under Section 14 of the new LA Act if the preliminary notification under Section 11 is not issued within 12 months from the date that such a report is submitted. In such an event, fresh social impact assessment study has to be undertaken before acquisition proceedings are initiated. It is pointed out that the first schedule to the new LA Act states that the market value of the land is to be determined as per Section 26 thereof. The proviso to Section 26 subclause 1 of the new LA Act in turn links the market value to the date on which the preliminary notification is issued under Section 11. The notification under Section 11 of the new LA Act is equivalent to public notice issued under Section 15 subclause 2 of the Highway Act. The declaration under Section 19 of the new LA Act is on par with the notice published under Section 15(1) of the Highway Act. In the context thereof, it is pointed out that Section 19 subclause 7 of the new LA Act prescribes the time limit of 1 year between the notification under Section 11 and publication of declaration under Section 19, and in the event of failure to abide by this time stipulation, the preliminary notification is deemed to lapse, subject to exception in terms of the second proviso to Section 19, subclause 7 of the new LA Act. Similarly, Section 25 of the new LA Act provides that the award must be passed within 12 months of the declaration under Section 19, if not, the entire proceeding would lapse, subject to proviso to Section 25, which entitles the government to extend the time. As all these provisions do not find reflected in the first review to the new LA Act, which has been extended to the Highways Act, the timeline put in place to safeguard the interest of the land owner would not be applicable to the acquisition thereunder. In consequence, there would be no restriction upon the state of Tamil Nadu to complete the exercise in a time-bound manner, and compensation would be determined by taking into consideration the market value from the distance past, which would not be the case had the acquisition been under the new LAR. In the light of flexibility afforded to the state government, it is argued that the market value of the acquired land would change to the detriment of the landowner. It is further pointed out that the procedure prescribed in Section 28 of the new LA Act for determining the amount of compensation is not followed by the state of Tamil Nadu under the Highway Act, and more particularly the power given to the collector under Section 28 subclass 7 of the new LA Act to take into consideration and any other ground which may be in the interest of equity, justice, and beneficial to the affected family. It is also their grievance that safeguards provided in the new LA Act, which are beneficial to landowners, are not available in the Highway Act, both in relation to the quantum of compensation as well as procedure. Reference is made to Section 39 of the new LA Act, which provides for additional compensation in case of multiple displacements, and it is pointed out that no such relief is provided in the Highway Act despite multiple acquisitions for widening of highways. It is contended that though the Validation Act of 2019 applies the provision of the new LA Act to the Highway Act insofar as compensation is concerned, the selective application of the provisions of the new LA Act would result in discrimination even in the matter of compensation. It is pointed out that timelines prescribed under the new LA Act, which are not relatable to the first review to the new LA Act, are not made applicable under the Validation Act of 2019, and the absence of such a timeline would permit the state to peg the market value for determining compensation on a date in the remote past, thereby depriving the landowner of just and fair compensation. Accordingly, according to the learned counsel, though there is due jure parity between the new LA Act and state acts, there would actually be de facto discrimination in the payment of compensation. Reference is made to PV Mudaliar versus Special Deputy Collector Madras and others, AIR 1965 SC 1017, Nagpur Improvement Trust and others versus Vittal Rao and others, AIR 1973 SC 689, Union of India versus the Same Singh and others 2019, Volume 9, SCC 304, Svitri Kere and others versus UP Awas Imam Vikas Prichard and others 2003, Volume 6, SCC 39, and State of Madhya Pradesh versus GC Mandawar AIR 1954, Supreme Court 493. It is asserted that there is no intelligible differential between landowners whose lands are acquired under the Highway Act and those whose lands are acquired under the new LA Act, and it would amount to an unreasonable classification if they are denied compensation on the same term when their lands are acquired for public purpose. An example is cited where a person's land may be acquired under the Highway Act while his neighbor's land, which is identically situated in all respects, is acquired under the new LA Act. But they would be given compensation on different criteria owing to the absence of timeline in the Highway Act, which would permit the state to peg the market value on the past date to determine the compensation, unlike the situation obtaining under the new LA Act. Reference is made to Joseph Shine versus Union of India, 2019, Volume 3, SCC 39, to contend that when a statute is arbitrary, it would offend Article 14 of the Constitution and would require to be struck down. It is also argued that certain critical clauses pertaining to compensation contained in Section 27 to 30 of the new LA Act are not brought into play in the Highway Act as only first due to the new LA Act has been incorporated therein, causing discrimination as landowner whose land has been acquired under the Highway Act would not be entitled to benefits under these provisions of the new LA Act. On the other hand, Mr. K. Venugopal, Land Senior Counsel, would point out that the timelines fixed in the new LA Act are not sacrosanct and the provisions thereof permit extension of time in circumstances. It is pointed out that once such a extension is granted, no outer limit is prescribed, and therefore the argument that the new LA Act places binding temporal constraint on the state is not correct. It is pointed out that the second provision to section 19 subclass 7 of the new LA Act empowers the government to extend the period of 12 months if, in its opinion, circumstances exist to justify the same. And in effect, there is no distinction between the Highway Act and the new LA Act. Reference is made in this regard to State of Kerala and others versus T.M. Patel and others 1980 Volume 3 SCC 554. Reliance is placed upon the State of Karnataka versus Ranganatha Reddy 1977 Volume 4 SCC 471 in support of the contention that a state law enacted on a subject in the concurrent list in the seventh due to the Constitution would stand protected after it received the assent of President under Article 254, subclause 2, even if it is repugnant to the central legislation on the same subject. And it is argued that any such repugnancy would stand cured and would no longer be a ground to invalidate the Highway Act. It is contended that the question of comparing the Highway Act with the new LA Act would not arise at all, as any repugnant provision in the Highway Act would continue to operate, notwithstanding the contrary provision in the new LA Act, as the Validation Act of 2019, which revived the Highway Act, should be protected by the assent given by the President of India under Article 254, subclause 2. It is pointed out that the public notice under Section 15, subclause 2 of the Highway Act was issued on 2nd July 2016 and was followed by publication of notice under Section 15, subclause 1 thereof on 1st February 2017, merely 7 months later. It is argued that even in a case where a delay ensures due to a factor beyond the control or any other incidental reason, it would not be sufficient in itself to declare the legislation void on that short ground. Having given serious and thoughtful consideration to the matter, we must take first note of certain crucial aspects that practically clinches the issue. The very foundation and basis of Article 254, subclause 2 of the Constitution is that A particular state enactment runs contra to the provision of central legislation on the same subject, but despite the same, it would stand protected after it receives the assent of the President of India thereunder. Therefore, it is a foregone conclusion that disparity and discrimination would be writ large between the two enactments and aspects relating to their implementation. In such a situation, the question of comparing the two legislation for the purpose of making out a cause under Article 14 of the Constitution would not arise. Such an exercise would be akin to comparing chalk with cheese, the two essential unequal entities. Notably, in GC Mandavar Supra, a constitutional bench observed that it is conceivable that when the same legislature enacts two different laws, what in substance they form one legislation, it might be open to the court to disregard the form and treat them as one law and strike it down if, in their conjunction, they result in discrimination. But such a course would not be open where the two laws sought to be read in conjunction are by different governments and by different legislatures. Art, as Article 14 does not authorize the striking down of a law of one state on the ground that, in contrast with the law of another state on the same subject, its provisions are discriminatory and nor does it contemplate a law of the center or of the state dealing with similar subjects being held to be unconstitutional by a process of comparative study of the provisions thereof. The bench pointed out that the source of authority for the two statutes being different, Article 14 can have no application. This was the very logic that was applied in this by this Honorable Court, Supreme Court in Nanthi Amal while upholding the validity of Tamil Nadu acquisition of land for Harijan Welfare Schemes of Act 1978. In P. Bajravelu Badalier, a constitutional bench, while dealing with an amendment to the old LA Act brought by the Madras legislature, whereby different principles were specified for fixing compensation for land acquired for housing scheme when compared with acquisition for other purposes. Significantly, this was not a case where presidential assent was obtained under Article 254, Subclause 2 of the Constitution. It was in those circumstances that when observed upon a comparative study of the old LA Act and amending Act that if the land is acquired for a housing scheme under the amending Act, the claimant would get a lesser value than what he would get for the same land if it was acquired for a different purpose, for public purpose under the old LA Act. And such classification between persons whose lands were acquired for housing scheme and those whose lands were acquired for other public purpose would not be reasonable one under Article 14. It was on that ground that bench held that Magdi Act to be void as it clearly infringes Article 40 of the Constitution. Similar was the situation in Deputy Commissioner and Collector Kamrup versus Durganath Sharma AIR 1968 SC 394 and Nagpur Improvement Trust Supra, as those cases also did not involve validation of repugnant state law under Article 254, Subclause 2 of the Constitution. In Ranganatha Reddy's, a constitutional bench of 7 judges observed that the repugnancy, if any, between state act and central legislation on a subject in the concurrent list would stand cured if the state act received the assent of the president under Article T254 subclause 2, and such repugnancy cannot thereafter be a ground to invalidate the State Act. Again, in Javed and others versus State of Haryana and others, 2003, Volume 8, SCC 369, a three-judge bench of this court held that it is not permissible to compare a piece of legislation enacted by the state in exercise of its own legislative power with the provision of another law, though parliamentary. It may be, but enacted by Parliament or by any other state legislature within its own power to legislate. As the sources of power are different, so do differ those who exercise the power. It was observed that these that two laws enacted by two different governments and by two different legislatures can be read neither in conjunction nor by comparison for the purpose of finding out if they are discriminatory, and Article 14 does not authorize the striking down of law of one state on the ground that, in contrast with the law of the center of or of another state on the same subject, its provisions are discriminatory. In UP Awam Vikas Parishad versus General Islam and another 1998, Volume 2, SCC 467. This court, while dealing with a state act for acquisition of land for executing housing scheme. However, the compensation payable thereunder was lesser than the payable under the old LA Act. The state law was of the year 1965 and received the assent of President. However, the old LA Act was amended by the Land Acquisition Amendment Act of 1984, whereby several new provisions were inserted in the interest of the landowners by enacting the amount of solitium and interest. The State Act of 1965, however, remained unchanged. The High Court came to the conclusion that landowners would be entitled to benefit of the provision introduced in the old LA Act by the Amendment Act of 1984. The matter thereupon came before this court. This court held that Section 55 of the State Act of 1965, which incorporated the provisions of the old LA Act, also intended that amendment to the old LA Act relating to the determination of compensation would be applicable to the acquisition of land under the State Act of 1965. Owing to this construction and interpretation of the statutory provision, this court held that it would not be necessary to deal with this submission that if the provisions of Amendment Act of 1984 were not applicable to the acquisition under the State Act of 1965, the provisions of the old LA Act made applicable under the Act of 1965 would be void on the ground of repugnancy under Article T44 of the Constitution. This judgment therefore does not aid or advance the case of the appellants. Similar logic was applied by this court in Svitri Supra while dealing with the very same State Act of 1965, noting that it provided for acquisition of land in terms of the old LA Act and by reason of the legal fiction created thereunder. This court held that even if the acquisition was made under the State Act of 1965, if a higher amount of compensation is payable under the old LA Act, such a higher amount of compensation had to be paid. Pertinently, this court observed that ordinarily the equality clause enshrined in Article 14 of the Constitution cannot be invoked in the matter of enforcement of state legislation versus parliamentary legislation or legislation of another state. We are therefore not inclined to entertain the attack launched against the Highway Act on the strength of so-called disparity and discrimination in the norm and procedure prescribed therein when compared with the new LA Act. In this regard, we may point out that Highway Act in the state of Tamil Nadu stood protected even at the time of old LA Act was in force and effect, owing to the presidential assent that it had received under Article 254, subclause 2 of the Constitution, and it continued to operate and provide altogether different jurisdictions to for acquisition of land and payment of compensation till the advent of new LA Act. Even otherwise, insofar as the issue of social impact assessment and timelines for various steps in the new elect are concerned, this very argument was advanced in G. Mohan Rao, and this court observed that the whole exercise of pointing out any repugnancy after a validating act has obtained the assent of representatives or twice for the whole purpose of Article 254, subclause 2 of the Constitution is to resuscitate and operationalize a repugnant act or repugnant provision of such act. This inescapable fact that also remains that second proviso to section 19 subclass 7 of the new Act empowers the appropriate government to extend the stipulated period of 12 months for publishing the declaration after issuance of preliminary notification, if in its opinion circumstances exist to justify the same. The third provision requires that any such a decision to extend the period shall be recorded in writing and shall be notified and uploaded on the website of the authority concerned. More importantly, once such extension is granted, there is no outer limit prescribed and the proceeding would not lapse owing to time stipulation. In T.M. Peters, while dealing with the attack against absence of time limit for government sanction in the Town Planning Act 1932, this court observed that as the scheme of the said enactment was urgent improvement of the town and it was left to the government to deal with it with expeditious dispatch, no precise time scale could be fixed in the act owing to the myriad factors which would have to be considered by the government before granting sanction to the scheme, and concluded by stating that the court would not be powerless to quash and grant leave where arbitrary protraction or malevolent inaction of the authorities caused injury to the owner. No doubt, the scheme of the new LA Act advocates timely measures being adopted in implementation of the acquisition, and such a general temporal restriction would benefit the landowner, but the absence of such restriction in the Highway Act may not be reason and to invalidate it, as the very premise on which the Highway Act was enacted by the state of Tamil Nadu was to cut down on time-consuming processes. In G. Mohan Rao Supra, this court had noted that the letter dated 25th July 2019, written by the state of Tamil Nadu for obtaining the assent of the President of India for the Validation Act of 2019, specifically emphasized that the three states act were made for the purpose of speedy acquisition, but the new LA Act rendered them repugnant. Therefore, it is not the intendment or purpose of the Highway Act that the processes for acquisition of land thereunder should be protracted or be ridden by wide village. A particular instance or a stray case involving some delay in the acquisition of land under the Highway Act may have to be dealt with on its own individual merit, but that would not be sufficient in itself to invalidate the legislation itself. I noted above, K.M. Vittal Babu and T. Chinnappan have already approached the Madras High Court challenging the individual acquisition proceeding initiated against them, and those cases have to be considered on their own merit and in accordance with law without reference to this education, which is limited only to the attack on the validity of the Highway Act. Further, there is no possibility of State Tamil Nadu exercising arbitrary discretion in adopting one legislation or the other for the purpose of acquiring land as contended by the Land Council. Section 3711 of the Validation Act of 2019 expressly exclude the operation of the new LA Act for the purposes contained in the state acts which stood revived owing to the assent of the President of India. Therefore, the state of Tamil Nadu would be bound to apply on the Highway Act for acquiring land for the purpose reserved thereunder. On the above analysis, these appeals are bereft of merit. The Tamil Nadu Highway Act 2001 is not liable to be invalidated on the ground that its provisions manifest discrimination or arbitration when compared with the provisions of the right to fair compensation and transparency in land acquisition, rehabilitation, and resettlement Act 2013. So this is all about my topic. Thanks for watching. God bless you all.